in 5, 4, 3, 2, 1.
This Honorable Court of Appeals is now in session.
Thank you, Mr. Hübner. And on behalf of Judge McBrayer and Judge Davis, we welcome counsel to this oral argument, which we are live streaming to fulfill our obligation to maintain our open courts. We will hear from counsel in the same fashion as if we were all together in the courtroom. Each of you has 15 minutes, and of course the appellant has time for rebuttal. Unless there are any announcements, I'll ask Mr. Hübner to call the case.
Your Honor, I'm not sure if Mr. Wilson and I covered the rebuttal time or not. So,
Mr. Wilson, do you want some rebuttal time?
Yes, Your Honor, I'd like to reserve 3 minutes.
3 minutes, very good. Then Mr. Hübner will program the clock so it'll start at 12.
thank you, Your Honor. Popularcategories.com Inc. versus Reagan, Farr, Commissioner of Revenue.
Mr. Wilson, you have the floor.
Is the clock? I don't see the clock. Oh, there we go. Okay.
So Mr. Hübner sometimes keeps that hidden just so he can surprise you.
There we go. Good morning, Your Honors. I'm Chris Wilson. I represent the appellant. The central issue in this case involves the sourcing of PopCat's receipts from the sale of its membership interest in Popular Enterprises for Tennessee apportionment purposes. As this court is aware, in Tennessee, the apportionment formula at issue is comprised of 3 factors: a property factor, a payroll factor, and during the period at issue, a double-weighted sales factor. It's undisputed in this case that both the property factor and the payroll factor are 0. So the sole issue focuses on the calculation of the receipts factor, which is a fraction where the numerator constitutes the total receipts in Tennessee and the denominator constitutes total receipts everywhere. In order to determine whether or not a receipt constitutes a Tennessee receipt for purposes of this fraction formula, we look to the cost of performance test under Tennessee law. And this is what controls whether receipts from intangibles, such as the sale of the membership interest in this case, are sourced to Tennessee for this purpose. And under the cost of performance test, when earnings producing activity occurs both inside and outside of this state, the receipts are sourced to the state where the greater proportion of earnings producing activity based upon direct costs of performance occurs. This is an all or nothing test. And whether an expense is a direct cost of performance for purposes of doing this methodology is determined by looking to generally accepted accounting principles, or as I'll refer to it as GAAP.
And your position is, or I guess you're saying it has to be a direct cost, right, to factor into this cost of performance test?
Yes, Your Honor, that's correct. So beyond also looking at GAAP, the Rule 34 of Tennessee's franchise and excise tax regulations, Rule 34 specifically excludes costs paid to third parties as direct costs. So examples of these costs could include costs paid to accountants or costs paid to attorneys who are involved in a transaction. With regard to an earnings producing activity itself, this is separately analyzed with regard to each item of income. The item of income here in this case is the proceeds from the sale of PopCat's membership interest. And the earnings producing activity in this case related to that item of income is PopCat's activities to facilitate the sale. In this case, the trial court incorrectly expanded the scope of earnings producing activity to also include PopCat's activity of monitoring its investment in Popular Enterprises prior to sale. However, I would like to point out that this has no net effect in this case because the record contains no direct costs incurred by PopCat in Tennessee during the course of such monitoring activities. No costs, either direct or no direct cost noted in the record period. In this case, the court committed clear error on a couple of points. First, I'll point out that the court committed clear error by granting summary judgment in favor of the commissioner because the court erroneously concluded that PopCat ascribed no direct sales activities to Florida. The record in this case, though, shows that this is completely untrue. PopCat, through its expert, presented evidence that it incurred more direct costs of performance in Florida than in Tennessee during the time period at issue. The court somehow missed this. The department, through its expert, disputed that these Florida expenses constituted direct costs under GAAP for purposes of applying the cost of performance methodology. This factual dispute is material. It absolutely goes to the very core of the issue in this case. Thus, it was improper for the trial court to grant the commissioner's summary judgment in light of this disputed issue of material fact that is plain in the record itself.
Is that a factual issue, or is that a conclusion of law that the court has made about how to treat those costs?
That, Your Honor, is an issue of fact. It's an issue of fact. Tennessee law refers to a determination utilizing GAAP principles. And in this case, you have two experts that were brought in, one for the commissioner, one for PopCat, to provide factual proof regarding the fact whether these costs were direct or not direct under GAAP. And there was a disagreement between the experts on that factual issue. But Your Honor, I submit it's an issue of fact that is delved into by referencing GAAP. In this case, Your Honor, the court also erred by disregarding undisputed proof from both sides, showing that the greater proportion of direct costs of performance occurred outside of Tennessee. Specifically, the commissioner's expert concluded that there were zero direct costs in Tennessee, but a small amount that were incurred in Colorado. PopCat's expert concluded that there were a small amount of direct costs incurred in Tennessee, but that these costs were far outweighed by direct costs incurred in each of numerous other states, including Florida, where PopCat undisputedly had taxable nexus in this matter. Thus, both experts agreed that the greater proportion of direct costs were incurred outside of Tennessee. And this undisputed fact should have resulted in a grant of summary judgment in PopCat's favor. However, the trial court improperly rejected this undisputed proof by ruling that, quote, if a taxpayer does not have tax nexus with the state, activities or direct costs incurred in such state are not relevant. Your Honors, as set forth in our briefing and in the briefing of the amicus, this is the judicial adoption of a throwback rule, under which the trial court simply ignored direct costs incurred in states other than Tennessee and Florida, being the states where PopCat undisputedly had a taxable presence. As further explained in PopCat's brief and in the brief submitted by the amicus, under Tennessee law, the existence of taxable nexus with a particular state has nothing to do with whether receipts can be sourced there for purposes of apportionment. While UDIPA's Model Act provides for a throwback rule, the Tennessee legislature expressly declined to adopt UDIPA's throwback provision as a matter of tax policy when it adopted provisions of UDIPA into Tennessee law in 1976. As cited in our briefing, such a decision is viewed as an economic incentive to attract business into the state, since throwback rules have also been generally recognized to yield uncompetitive levels of taxation, causing businesses to choose to locate elsewhere.
Where would you say your client's commercial domicile is located?
Where would I say their commercial domicile? I will say this with regard to commercial domicile, and I know that it's referenced in the briefing by the commissioner. Commercial domicile is not relevant with regard to apportionment. A commercial domicile becomes relevant when you're dealing with an issue of allocation of non-business income under Tennessee's
But I mean,
statute.
don't the treatises say that what the Uniform Act, I'm not going to use that acronym, but the Uniform Act is designed in order to assign intangible property sales to the commercial domicile of the taxpayer. I mean, if that's the case, it seems like that's what the chancellor's ruling does here.
Your Honor, in this case, what we're dealing with apportionment of income and sourcing of receipts.
Well, I
and
get
of
that,
business income.
but we've got to read these statutes with some degree of common sense to them, right? I mean, it seemed like we were getting very far into the weeds on how to read on the apportionment portion here, and you know, this is this is a sale of an intangible. It's not a regular activity, is it? It's sort of a unique activity. So I'm not sure I follow the regular activity argument at all, but anyway, it's unique activity here. That looks like it all happened in Tennessee to me.
Your Honor, under what we're bound to under law is to look to Tennessee's apportionment provisions, which apply the cost of performance methodology, and you look where are the direct costs, the greater.
Well, what if I
proportion of
don't
direct
get
costs
to
occur.
that? What if I don't get to subpart 2 of the statute? What if I just say, well, gosh, it looks like to me we're just in subpart 1. It's in this state, and I don't go any farther.
Your Honor, the commissioner's own expert in this case has asserted there's no direct costs in Tennessee, and the proof in the record shows that the greater proportion of direct
I only
costs were
worry
incurred in
about
other
direct
states.
costs, don't know if I get to subpart 2 of the statute.
Well, in this case, though, there was activity that occurred in multiple states. In order to have a sale of an asset,
that wouldn't necessarily mean, though, that had any involvement with the sale here.
absolutely, it has an involvement with the sale here. You don't have a sale if you don't locate a purchaser, if you don't negotiate the terms, and the proof in the case here shows that costs were incurred in multiple states during this process, without which there would not be a sale with generating the income at issue. So, and that was a multi-state activity.
Let me just make sure that I understand big picture, your argument. Big picture is the earnings producing activity was the sale of the business. And under your theory, what the apportionment of tax depends on what percentage of activities that were directed towards the sale of the business took place in what state. And your expert says none, basically 2% maybe, took place in Tennessee. It took place everywhere else. But we don't need to concern ourselves whether the other states can or cannot collect that tax. We just know that Tennessee, none of the activities occurred, so no tax is owed in Tennessee. Is that right?
Both experts in this case, Your Honor, have the same conclusion that the greater proportion of earnings producing activity occurred outside of Tennessee. So I think that is correct. Your logic is following that conclusion. Okay. Yes.
All right. Just making sure.
Sure. No, in this case, judicially permitting the commissioner to impose a throwback rule usurps the constitutional authority granted to the legislature to set tax policy in Tennessee, and as noted by the amicus, would create economic instability and unfairness to business taxpayers in Tennessee. For all these reasons, the Chancery Court's ruling must be reversed, and we submit that summary judgment is properly awarded in PopCat's favor when you apply the principles of apportionment and sourcing set forth in the Tennessee Code. As noted, we're dealing with business income in this case. It's undisputed. It's the law of the case that we're dealing with business income, which deals with apportionment. Allocation principles, which would focus on commercial domicile, deals with non-business income. That's an issue that's been decided by the previous Court of Appeals on the prior trip up here. So apportionment principles prevail in this case.
Thank you, Mr. Wilson. We'll hear from you again on rebuttal. General Knack.
Thank you, Your Honor.
Thank you, Your Honor. Again, I'm Mary Ellen Knack at the Attorney General's Office. I represent the Commissioner of Revenue in this case. As the taxpayer seeking apportionment, the plaintiff had the burden of identifying the earnings producing activity at issue and establishing that a greater proportion of the activity occurred in a state other than Tennessee during the tax periods at issue. And the rule, as Mr. Wilson noted, the rule defines earnings producing activity as transactions and activity directly engaged in by the taxpayer in the regular course of its trade or business for the purpose of gain or profit. The principal of the plaintiff, Mr. Bookstuff, testified that this company was in the business of monitoring its investment in Popular Enterprises in Knoxville, and that's the same city where Popular Enterprises managed the assets. So the plaintiff's regularly engaged in activity was not the sale of 100% of its assets.
But this is where the majority of the income here that we're taxing, right, is that's what we're talking about, right?
We are talking about the sale of its earnings from the sale of its only assets, yes.
Right. So, that's not a regular business activity, is it?
No, not for this company. No, its regular business activity was monitoring its
To
investment.
see, how they're doing on the advertising sales through the various domains that they owned. So, I mean, there's sort of a mismatch there. I want to go back and make sure I understand the state's argument here about how 67-4-201 little I or Romanet 1 applies here. So are you saying we don't get to subpart 2 there and look at cost of determinants, performance, or you're saying we do, it's just that the facts here don't support cost of performances outside the state?
I don't think you get to subpart 2. And part of the reason is this court's prior opinion. The plaintiff's expert, his theory of apportionment, his method of apportionment was based on 2 different theories, both of which are legally non-viable after this court's prior opinion. Again, the plaintiff had the burden of establishing that the earnings producing activity occurred in another state during the tax periods at issue. The tax period at issue is 2006 and 2007. As this court noted in its previous opinion, the expenses that were incurred in 2005 were isolated solicitation efforts that occurred before the tax years in question. And those efforts were not enough to, the court held that therefore the plaintiff was not doing business in any other state based on those activities.
But I mean, there we were analyzing whether or not pop categories could be subject to taxation in those states. I mean, that's what it sounds like, before ultimately concluding that apportionment was appropriate. So, I mean, to me, our prior decision doesn't foreclose our ability to determine that states other than Florida and Tennessee are, possible states to apportion income.
Under UDIPA, income should never be apportioned to a state without. It should never be apportioned to a state where only isolated solicitation efforts are occurring.
So would you also say then it could never be apportioned to a state where there's not sufficient nexus for tax purposes?
We did make that argument, but I do not think the court necessarily needs to go that far. I think that these are isolated solicitation efforts that did not impact on the plaintiff's right to apportion, and they just don't rise to the level of an earnings producing activity performed in another state. And if they do, they're not being performed during the tax years at issue.
So what was the earnings producing activity that is being taxed? Like and forgive my ignorance on these issues, but what we're taxing here is the sale of the business, correct? Proceeds from the
yes.
sale of the business.
Yes.
So that is therefore the earnings producing activity that we need to be concerned with, right?
I don't think so. I think that the earnings producing activity is activity directly engaged in by the taxpayer in the regular course of its trade or business. And Mr. Bookstaff testified that they were in the business of monitoring this investment.
And that's based on application of the regulation cited in your brief at 0.342, correct?
Yes, I'm relying partly on that. As I noted, I'm also relying on the court's previous decision.
Yeah. Is there another regulation that addresses non-ordinary business transactions like this one when it's out of the ordinary course, the sale of this membership interest? Is there another regulation that would apply, or is it's all just assumed to be regular course activity?
I am not aware of another regulation.
Okay.
I can't affirmatively state there's not, but I'm not aware of one.
Okay.
The second group of travel expenses that the plaintiff's expert focused on were the court has held that those activities cannot be attributed to the plaintiff. That second theory of apportionment was based on the argument that a partnership arose between the plaintiff and the purchaser of its assets, Internet REIT. The court specifically rejected the argument that a partnership existed, and again, specifically rejected the argument that Bookstaff's post-sale travel could be attributed to the plaintiff. The result advocated by the plaintiff directly contravenes UDITPA's purposes, the Uniform Act's purposes, which is to tax neither more nor less than 100% of its income, to approximate the corporate income that is reasonably related to the activities conducted within the taxing state, and to avoid the creation of nowhere income. What the plaintiff has done is attempted to assign 100% of its earnings to nowhere income, meaning income that is not taxable in any state. And that goes against our Supreme Court's holding in the Vodafone decision. As Hellerstein has observed, the application of Section 17 of the Uniform Act ordinarily results in the assignment of income from the sale of intangible personal property to the taxpayer's commercial domicile where the intangible personal property was managed. And I would submit that this is a recognition that, generally speaking, the management of the asset, and in this case, the monitoring by the plaintiff and the management by Popular Enterprises would be the earnings producing activity.
And so is subsection 2012, is that directly taken from section 17 of the Uniform Act?
It is. There may be a slight deviation. I think the Uniform Act may refer to income producing activity, while the Tennessee version refers to earnings producing activity, but we have always treated that language as meaning the same thing. The existence of a throwback rule, whether or not Tennessee has adopted the throwback rule is irrelevant. The throwback rule that the plaintiff is citing has only to do with tangible personal property. Section 17 is the standard for sales of intangible personal property. And in order for income to be allocated to a state other than Tennessee, the plaintiff must be engaged in an earnings producing activity in another state. Again, I would submit that isolated sales efforts are not sufficient to constitute an earnings producing activity in another state. After all, the goal of UDITPA is we're trying to find the state that has the greatest or the closest relationship to this income.
But the earnings that are being taxed are not the earnings that are directly attributable to the management of the intangible asset. The earnings that are being taxed are the proceeds from the sale, correct?
We are taxing income from the sale of the asset, but I do not think it is correct to say that those earnings result solely from sales efforts. Those earnings also result from the creation and the management of that wealth and the monitoring of that wealth in Knoxville. And nobody disputes that Knoxville is where all that occurred. I would like to briefly address Florida. The facts regarding the plaintiff's activities in Florida are undisputed. It's contrary to the plaintiff's argument that we do not have a genuine issue of material fact that requires a trial. What is disputed is the legal inferences that can be drawn from those undisputed facts. And those undisputed facts are that plaintiff's representatives traveled to Florida twice in 2005. They listed a private residence in Longwood, Florida as its principal office until February 2006. But the owner of that residence had terminated any affiliation with the plaintiff by November 2005. Sometime in 2007, Mr. Bookstaff traveled to Florida to dissolve the plaintiff's corporate charter. But again, none of these activities, they either predate the tax years in question, or they're not an income producing activity, as we've cited in our brief. Reinstating a corporate charter or dissolving a corporate charter do not constitute earnings producing activities. My reading of this court's earlier decision and my interpretation was that Florida was the only other state with nexus. So the plaintiff is incorporated in Florida, but we don't have evidence that the plaintiff was engaging in any earnings producing activity there. And again, this goes back to the notion that the court's previous conclusion that isolated solicitation efforts that occurred before the tax years in question should not impact the apportionment analysis. So when we got the earlier decision, I expected on remand, the fight would be, okay, we have only two states with nexus, Florida and Tennessee. So which state is going to get these earnings? Clearly the answer here should be Tennessee based on the undisputed facts in the record.
And so did ultimately the trial court, was anything apportioned at all then in the final analysis? It all was assigned to Tennessee?
Everything was assigned to Tennessee. And so under 212I, which is also Section 17 of the Uniform Act, under that provision, it is an all or nothing proposition. It's 100% goes to Tennessee or 100% goes to some other state where the plaintiff has shown that it's engaging in an earnings producing activity during the tax periods at issue.
So that's assuming, but just want to make sure I'm clear. So I'm looking at 67-4-2012 Romanet I or I. The state's position is you got to one, it was all in the state, and then you stopped there, right?
Yes.
Okay. Not that you got to subpart 2 and started worrying about cost of performance, or do you say you got to cost of performance and the state won on that as well?
I don't think you need to get to part 2 based on this court's previous opinion. And I forgot to mention, the courts also specifically dealt with the Telluride ski trip and rejected the argument that it said that, plaintiff was on a ski trip. He's not doing business in Colorado.
Yeah, but I guess looking back at that case though, yeah, they're saying, well, that's not sufficient nexus for taxation in Colorado. I don't know that necessarily excluded some amount of this sale from being apportioned to, I can imagine a situation where, there was advertisements in the state and the buyer discovered this membership interest was sold by looking at a newspaper in Colorado. And, that you might put some cost there if, again, if you decided that was part of the thing that led to the sale.
Anything further, General Knack?
No, just to reiterate that unfortunately it's an all or nothing. And I think it's clear in this case that the state of Tennessee has the closer relationship to these earnings than any other single state the plaintiff can identify. Thank you.
Thank you. Mr. Wilson? You'll need to unmute, please. Your argument will be more persuasive if you do that.
The price of technology, Your Honor, I apologize.
Quite all right.
Yes, Your Honor, I'd like to touch on a few points raised by General Knack. First, with regard to earnings producing activity in this case, I think the questioning hit the nail on the head. They're taxing the income from the sale of the membership interest. Without that sale, there would be no income to fight over in this case. You don't have a sale without a purchaser, without a negotiation, without all of those steps in order to facilitate that sale. And in this case, it's clear the earnings producing activity for this item of income that's being taxed is the sales activity itself. And I'll also
Well, but
note
we
that
are
under
talking about franchise and excise taxes, right? So there is some worth questions in here as well.
there would be worth questions, but the apportionment formula applies the same manner for both.
Yeah.
So, but you're correct, it's franchise and excise tax. And I will note with regard to whether or not the sale of an asset is part of an earnings producing activity, you can look to the definition of business income itself in 67-4-2004 subpart 4, which also incorporates the sale of assets, of entity assets as part of business income, subject to apportionment.
Yeah, Mr. Wilson, I think I might have interrupted you before you addressed my concerns about the state taxation treatise, saying that Section 17 of the Uniform Act was basically designed to place income on sales such as what we've got here, where the corporation is domiciled. And I think I interrupted you before you had a chance to sort of finish. You said it's irrelevant. That's only an allocation thing. But I mean, so you're basically saying the treatise is wrong. Was that your point?
I think we have to take the treatise in context. And I think we're referring to Hellerstein, which
Yes.
references a commercial home, a domicile. But when you read the full text, and as pointed out in our briefing, the full text, it references general principles regarding domicile, but at the same time, it also points out that where you have states that have adopted like for example, cost of performance methodology, if the direct costs are incurred in other states, that's what ultimately controls the outcome, not an overriding general principle that might have been behind UDIPA itself. And another thing to point out with regard to UDIPA, General Knack pointed out the goals of UDIPA taxing 100% of income. But in Vodafone, the court cited to a 1957 article by William Pierce. And when you read that article, you'll note that Professor Pierce presumed that a state adopted 100% of UDIPA, which would include a throwback rule under the General UDIPA Model Act. The Tennessee legislature, however, expressly declined to adopt that provision when it adopted UDIPA into Tennessee law. So Tennessee does not have the full act. And there's a legislative intent in Tennessee, I would submit from an economic perspective, to not address that nowhere income, as General Knack refers to it. And my time is run, but the principles with regard to that are cited in our brief.
Thank you, Mr. Wilson and General Knack. You have given us a lot to consider. We'll take this matter under advisement. Mr. Hibner.
The Honorable Court is now in recess until 1 p.m.
Thank you, and counsel, you're free to exit the meeting.
Thank you, Your Honor.
Thank you.